So, what happens when it's just one homeowner versus their entire condo association? Well, we're going to dive into a real world story about a fight over just one simple document. And trust me, it has some powerful lessons for anyone, and I mean anyone, living with an HOA.
You know, it's a question a lot of us have probably asked at some point. What can you actually do when your HOA just breaks its own rules? Well, one woman in Arizona decided she wasn't just going to ask, she fought for an answer. And in the process, boy, did she turn the tables on her board. They had no idea what was coming. Okay, so let's get into it. Our story, and really our fight, kicks off with Barbara Printy. She's a condo owner down in Phoenix at the Olive Grove Village Association. And look, all she wanted to do was see how the association was handling its money. I mean, that's a pretty simple, totally reasonable request from a responsible homeowner, right?
So back in early 2015, her request was about as straightforward as it gets. She just asked, hey, can I see the financial audit for 2014? That's it. This is, a totally standard document. It's supposed to be all about transparency. It really should have been a simple yes. But it wasn't.
No, it was definitely not a simple yes. Instead of getting that document, what she got was a whole pattern of delays and deflections. A runaround that would end up dragging on for almost a year and a half.
Okay, just look at this timeline. Her journey here is just a masterclass in frustration. She starts off with a verbal request in April 2015, and they tell her, oh yeah, it'll be ready by June. Well, June comes and goes, nothing. So in October, she gets serious and puts it in writing. Their response? Go ask the management company. Fast forward to March of the next year, and now they're trying to tell her it's going to cost every homeowner $35 just to see it. And get this, the audit finally shows up in October 2016, literally the day before their court hearing. You can't make this stuff up. And here's the real kicker in all of this. This wasn't just them being rude or unhelpful. No. Barbara Printy's request was backed up by cold, hard rules. We're talking both Arizona state law and, get this, the association's own governing documents. All right, let's start with the big one, Arizona state law. It's crystal clear. The law says an association's financial audit has to be done no later than 180 days after the end of its fiscal year. So for the 2014 audit, that means the deadline was around the end of June 2015. The association was already breaking the law before she even sent her formal written request in October. This is the part that's just unbelievable. The association's own rules were even stricter than the state law. Their CC&Rs, the main rulebook for the community, demanded an audit within just 90 days. That means the real deadline was way back on March 31st, 2015. And on top of that, their bylaws specifically said they needed a full audit for 2014 because it was an even-numbered year. I mean, they were breaking their own rules left and right. So when they finally got to court, the association actually tried to argue that their own documents were confusing. Yeah, right. But under questioning, their own representative had to admit it. There was no way around it. No matter which document you looked at, the CC&Rs, the bylaws, a full audit for 2014 was absolutely 100% required. They had nowhere to hide. So you can imagine, after getting the runaround for nearly a whole year, Barbara Printy knew that just asking nicely wasn't cutting it anymore. It was time to escalate. It was time to make things official. And that's exactly what she did. On March 23, 2016, she filed a formal petition. And this quote you see here, this is straight from the judge's final report. It lays out her case perfectly. She alleged they violated the CC&Rs, the bylaws, and the state law by failing to get that audit done. She wasn't messing around. And you gotta remember, taking the step wasn't free. Not at all. Ms. Printy had to shell out $750 of her own money just to file the petition and get a hearing. Think about that. She was literally putting her own money on the line to hold her board accountable. All right, so the case finally gets to a hearing in October 2016. About a month later, on November 14th, the administrative law judge issued her decision. This was it. This was the moment of truth. And the verdict? It was absolutely decisive. The judge ruled that the association had violated the law. Bam! The judge found that Barbara Printy had proven her case by a preponderance of the evidence, which is just a legal way of saying she was clearly in the right. The HOA had broken the rules, plain and simple. So what happened next? Well, first things first, the judge made things right for Miss Printy. She ordered the association to pay her back that full $750 filing fee. So she got her money back for having to go through all this trouble in the first place. But hold on, the judge wasn't done yet, not by a long shot. Citing the association's, and I'm quoting here, ongoing and flagrant refusal to comply, she hit them with a $5,000 civil penalty. Now that is not a slap on the wrist. That is a huge statement, sending a message that boards simply cannot get away with ignoring the rules or the people they're supposed to serve. So look, this is way more than just one person's story, right? This is basically a perfect case study. It's packed with powerful lessons for any homeowner out there who wants to make sure their own association is playing by the rules. So what can we all take away from this? What's the playbook for you? Well, it all starts with knowledge. You've got to know your rights under state law. And even more important, you need to read your own association's governing documents, the CC&Rs and bylaws. Next, document everything. Make your requests in writing. Keep a timeline of every single phone call, email, and meeting. And if asking nicely doesn't work, don't be afraid to use the formal dispute process. Yeah, it took Barbara Printy 18 long months of persistence, but she proved that accountability isn't just a fantasy, it's possible. At the end of the day, Barbara Printy's story proves one thing above all else. Knowledge is power. Seriously, when you understand the rules, maybe even better than the people who are supposed to be enforcing them, that's when you can demand accountability. So I'll leave you with this final, crucial question. Does your board know that you know the rules?